A one-on-one on the domestic and international implications of patent policy. To discuss, I have on today Brian Pomper, formerly Chief International Trade Counsel to Senate Finance Committee Chairman Max Baucus, now at Akin Gump. Thanks to the Innovation Alliance for sponsoring this episode. The Innovation Alliance is a coalition of research and development-based technology companies representing innovators, patent owners, and stakeholders who believe in the critical importance of maintaining a strong patent system that supports innovative enterprises of all sizes. Brian, welcome to ChinaTalk.
Thanks for having me, Jordan.
I think IP you can date back to the Greeks, but I will let you start this timeline wherever you feel most comfortable, Brian.
So I really always start with the U.S. Constitution because, as it turns out, in the original text of the Constitution, put aside the 10 amendments that form the Bill of Rights, the only right that is really included in the Constitution is the right of authors and inventors to the exclusive rights to their invention.
Yeah, so Article 1, Section 8, the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
That's it. There you go. Article 1, Section 8.
So, Brian, why did the founders care about this?
Why did the founders care about intellectual property rights? Well, as I understand it, the way the intellectual property system, the patent system worked in England was that only those who manufactured a product could have rights over their invention. And it was almost like a reward system from the government. It was like a benefit the government gave to you, where you would petition the government, and if you were well known to the government or you were a favored of the court, you could get this patent. In America, the idea was to democratize the process. The thinking being that there was a lot of inventive creativity among the American populace. It didn't just have to be rich people who had connections to the government that could, or frankly, the wherewithal to build a factory, who could support the American economy by promoting their invention. So that's why the Constitution reads that way that it does. And so in 1790, Congress passed the first Patent Act. So one of the first things I think the Congress passed was the Patent Act. So I am of the very strong belief that the patent system has been one of the foundational, critical, key components that helped set the American economy off on the right course and really developed a culture of unique, innovative creativity in the United States that honestly we still have today, that I think we still do enjoy.
Gotcha. So why don't you take us through the 19th century, if you will, Brian? How weren't patent rights respected in that era?
I would take a page out of my friend Professor Adam Mossoff, who's at George Mason and wears a variety of hats, but he's done a lot of this great historical research, as he and I and others for the last perhaps decade and a half have tried to educate policymakers when they are told that there are patent trolls taking over the American economy, that patent trolls are going after all these innovators in the United States. Adam is the one who really points out, actually, if you're really looking for a period when there was a lot of litigation activity on patents, it was in the 19th century. And most specifically, some of the very famous inventors, like, for instance, Alexander Graham Bell, who I think in modern parlance would have been considered a patent troll, but many people think of as one of the greatest inventors of all time. I think Thomas Edison could be called a patent troll, the Wright brothers. All of these just very well-known innovators had to litigate to make sure that they could get the exclusive rights to their invention that they were entitled to under their patents. But I don't think anybody at the time called them a patent troll. That's really an invention of late 20th century America. And that's an important inflection point, if I can talk a little bit about how our patent system has changed in the way that we view patents. In and around, I think, 1982, there was a commission that was looking at American competitiveness. This was during the period when Japan was rising and you had East Asian tigers, and there was a fear that the United States economy was losing its oomph relative to our foreign countries, other foreign countries. And one of the suggestions that came out of that commission was to have a unified patent court. And that created something called the Federal Circuit. The idea being that we wanted uniformity in how our patent law was interpreted across the United States instead of by different geographies having different interpretations, thinking that that would really help innovation in the United States. I point that out because it just feels so much different to me sitting where I am now, 40 plus years later, where there was such a recognition on the importance of patents to the development of the American economy that there was such attention paid to it from the standpoint of strengthening patent rights and ensuring predictability and stability of these patent rights. Today, I think really due to two separate strains of thought, there's been, I think, a sustained attack on the patent system for at least a generation, at least the last 20 or 30 years. And that is both on the standpoint from, I'd say, high technology goods and also from the standpoint of pharmaceutical products.
So why don't you take us into the 90s and 2000s? What are some big sort of legislative landmarks that changed the way patents work in America?
I'd say the high point of support for the intellectual property system in the United States and really globally was when the World Trade Organization came into existence in 1995, and the agreement on trade-related aspects of intellectual property rights, the TRIPS agreement, one of the agreements as part of the WTO, came into force. That was an agreement that provided common standards for how countries around the world, those who were members of the World Trade Organization, needed to treat intellectual property. This really was an initiative from the U.S. government to try to set a floor for every country, how they had to enforce intellectual property rights. The idea, I think, at the time was that the United States, as an extremely inventive economy with quite a few companies with very large patent portfolios, benefited from instituting into the intellectual property system a rule of law approach all over the world. And I think that worked. I think that really did work. There was, after that point, a bit of a backlash to the TRIPS agreement. I think there was a sense from some of the developing world that it was an agreement that was too one-sided. It benefited the developed countries more than those that were developing, those countries that already had a robust, innovative ecosystem and intellectual property system, to the detriment of those that were still just trying to climb up the development ladder. So there started to be a bit of a backlash. And I think there were really two other elements that led to erosion of support for the intellectual property system and specifically the patent system in the United States. The first I would say would be rising drug costs. So quite a few politicians are concerned about the high cost of biopharmaceutical medicines. And they point to patent rights as a reason why these medicines are as expensive as they are. Personally, I don't agree with that, but that's the argument that's made. And so you often see attacks made on the patent system by those who are motivated to try to reduce the price of prescription drugs. So that's the first real line of attack on the patent system in the United States. The other one is one that I have worked with quite a bit as the executive director of the Innovation Alliance. And this is my interpretation, I should say, that after the bursting of the internet bubble, there were quite a few companies that didn't have any assets remaining other than their intellectual property. And those patents were then sold, which led to quite a bit of litigation on the part of companies who purchased the intellectual property to maybe to monetize them. That's the sort of patent troll narrative. But even more importantly, Jordan, and this is really what I want to get across, the late 90s and the 2000s saw the rise of these gigantic technology companies. We all know them, who they are. They're still around. They're the largest companies really the world has ever produced And these companies, while highly, highly innovative and extraordinarily successful, aren't innovative and aren't successful because they are relying on their patents. Some of these companies are advertising companies. Some of these companies are retail, effectively online retail companies. Many of these companies package other people's inventions into products that they then sell. What all of these companies had in common, for them, patents were a cost because they were selling products, not technologies per se. And again, those products often incorporated lots of other people's technologies. So if you're selling a product, think for instance, say a desktop computer that has tons of different technologies in there implicating many, many, many patents. Chances are not terrible that you're going to be using somebody else's technology without permission, without a license. And so that will ultimately result in a request for a license and perhaps litigation if there's no agreement to license. So the rise of the high-tech industry and the business models of those companies really led to a circumstance where it was in their economic interest to challenge the foundations of the patent system, which really, to my mind, should provide stability and predictability in the patent system. If you're a patent owner, what you want is to know that that's a durable right. So you can go out and you can raise money and you can promise investors that this technology is yours and only you can use it, and you're going to create a company that implements that technology. If that patent can be challenged easily, if it can be dragged into court, if you can be dragged before an administrative tribunal, if you can put a cloud of uncertainty over that patent for years, that really hinders the ability of the inventor to attract investment and really develop the technology in the way that really otherwise they should be able to. And speaking as someone who cares about patent policy, I think that's a negative for the U.S. economy. I think the U.S. economy should welcome inventors, should make sure that inventors' rights are stable and secure so that they can attract the investment and become the next very large companies in the United States.
So let's point to one counterexample. Elon Musk, famously not a big patent guy. He said in the past that SpaceX basically patents nothing, arguments being, quote, patents are for the weak. And, anything we would patent with regards to our rockets would just be something that Chinese competitors could sort of copy and paste. And, clearly there is a lot of innovation and technology and engineering that's going into something like a Starship. So, I like sort of writing off companies that make products as not technologically forward, I think is maybe pushing it a bit too far. But, there are clearly different businesses that come at the sort of cost-benefit calculus of investing in big patent portfolios from a different perspective. So I guess, I'm curious for your take. Look, it's like a guy in a backyard or a small firm or even a firm that's focused on research and development as opposed to productization is going to have a hard time, competing with Elon Musk and SpaceX, for example. But I'm curious, how you think about and respond to those sorts of critiques.
Right. Well, first, I would emphasize I emphatically did not say they were not technology forward, right? I said they're highly innovative companies, highly successful. It's just that they don't use their patents in the way that many inventors do.
To monetize,
for them,
sure.
for them, it's mostly a cost. Well, monetize, but also to secure investment. Because you certainly can monetize your invention, or you can use your invention to attract investment so that you can create a SpaceX, that sort of thing. Different companies have different approaches. Effectively, what I hear Elon Musk saying is, I'm not going to patent my inventions because then the Chinese can rip them off and copy the technology. What he's referencing there is patents, of course, are public. They are public documents. The idea is if you get a patent, the trade-off is you get the exclusive use of that idea, that innovation, whatever it is, for 20 years from the date that you filed the application. You get the exclusive use of it. or more correctly, you get to exclude others from using it. But you have to make it public to the world. That's the trade-off. The idea is if you make it public, other people can learn from that technology and build upon it. If Musk is saying, I'm not going to get a patent because I'm afraid others are going to then steal that technology, then what he's really relying on is something called trade secrets. I personally think from the standpoint of what's best for the American economy and American innovation, I think trade secrets, which they have a role, certainly, but I think that's a negative if we turn to the point where we're relying more on trade secrets than on patents, because then you're not teaching the rest of the public what your technology is, and then it's very hard for people to build upon it. So I personally think that that's a bad policy outcome to say, well, I can just rely on trade secrets rather than patents. But regardless, the idea of having a patent, ask any venture capitalist, what's one of the first things that they ask about a company when somebody asks them to invest in it? One of the first things they will say is, have you patented the technology? I don't know if you're a fan of Shark Tank, Jordan.
Sure.
But that question is a very common question that the sharks ask of inventors when they're being asked to invest in their product. Do you have a patent on the product? And there's a very good reason for that. Again, they need to understand that if they're going to invest in this company, company A, that, company B isn't going to come along and make the same exact product and compete with them. So patents are undeniably useful for the American economy, but perhaps not for every business model like Elon Musk has proven.
So let's go back to the sort of like policy wars that have been fought over intellectual property over the past. I guess we're now in the 21st century. So what have been some landmarks in the 2000s that have changed the terms of debate on intellectual on
Sure.
IP?
Well, I will tell you again, some of the big high tech companies have fought very long and very hard for a very long time to change the patent system to suit their particular business model. And you alluded to this earlier, but if you are a small company going up against a very large, very well-resourced company, it's hard to sit at the table as equals unless you as the small company have the exclusive right to a particular technology that the large company wants to use. It's a patent that really levels the playing field in that negotiating sphere. So I think that's a very important thing in our system, that we should encourage innovative challengers to technology incumbents. I think that's how we grow and develop. Of course, big tech companies, they don't want challengers. They want to make sure they can preserve their market and their monopolies that they have created. So for the last, honestly, 20 years, these companies have pushed very hard for changes to the U.S. patent system, some of which they have gotten legislatively. In 2011, Congress passed a bill called the America Invents Act. And what that bill did, among many other things, was it created a process at the U.S. Patent and Trademark Office that allowed for the administrative challenge to patents that had been issued. The idea being, hey, patent office, you made a mistake in issuing this patent, you should revoke the patent. The idea really at the time was to create a cheaper, quicker alternative to patent litigation, which can take a long time and be quite costly, to deal with mistakes the patent office had made. As it turns out, what we've seen is that it's really provided a tool for very well-resourced accused infringers to go after patent holders. They can file multiple challenges at the patent office on multiple different grounds, lasting years and years, really grinding these smaller companies without much of the wherewithal to spend the money to hire the lawyers to defend against all of these challenges at the patent office. So there's a real sense of imbalance that we've in some respects created a bit of a monster in this post-grant challenge world. And so there are legislative efforts to try to bring more fairness and balance to that process. And make it look a lot more like the original drafters intended it to be, which is, again, a cheaper, faster alternative to patent litigation, not an addition to patent litigation. I would say also, importantly, while the companies that were pushing for changes to our patent system did succeed in getting the American Invents Act in 2011, there were many other changes that they did not succeed in getting. But to the degree to which they were unsuccessful getting them through legislation, they were successful in getting them through the courts. And I talk about the long-standing legislative campaign to make changes to the patent system. It was accompanied by a public relations campaign that really tarnished the patent system as a playground for abusers, for patent trolls, for people who really weren't inventors. They were just getting patents and then suing these larger companies opportunistically, that sort of thing. This patent troll narrative, which I think was always overblown, had a profound impact on judges, and I think led them to feel as if they had a responsibility to help provide some changes to the system or help provide some clarity to the system that would provide relief to those who were being challenged. So, and I want to just provide one very important example. In 2006, the Supreme Court decided in a decision called eBay versus Merck Exchange. It made it very hard for patent owners to get injunctions against further infringement. And what I mean by that, if you're a patent owner, Jordan, and you prove that not only is your patent valid, but I'm infringing it, still the court may not allow you to stop me from using your technology. And then all you're left doing is trying to talk with me about how much I'm going to pay you in order to use that patent, even though you can't even stop me from using it.
Yeah. So Brian, let's bring it up to the 2010s and probably the most famous patent fight of recent vintage, Apple versus Samsung. So how did the post eBay versus Merck Exchange landscape end up interacting with that famous fight?
Well, I think for those companies, I don't know that eBay mattered quite as much. The fight between Apple and Samsung, of course, was the equivalent in the patent world of global thermonuclear war. So it was all over the place in the courts, but most prominently, it was at the International Trade Commission, where Samsung sought to block from importation into the United States certain iPhones because of the allegation that they infringed Samsung's patents. This is a really critical point because the patent that Samsung accused Apple of infringing were something called standard essential patents. This is a unique type of patent. This is a patent that is incorporated into a standard that anybody in a particular industry must use. So for instance, if you've got a wireless standard, every cell phone in the world is pretty much going to use the same wireless standard. If a company has a technology that's incorporated into a standard that it has patented, that comes with certain responsibilities on the part of the patent owner. You have to, for instance, agree to license your patent on something called fair, reasonable, and non-discriminatory terms to anybody who wants to license your patent. And you can understand why there's that responsibility. I mean, my goodness, if every company that sells a cell phone has to use a standard because we want that interoperability around the world, that means by definition, if they're using the standard, they're using your patented technology and they're going to have to pay you to use it. And if you're the patent owner company, you know they have to use the standard. You could charge them an extortionate amount of money. So the rules of this whole system require that you don't charge an extortionate amount of money. You have to charge a fair, reasonable, and non-discriminatory rate. That's a standard essential patent. FRAND, fair, reasonable, and non-discriminatory, is purposefully not a defined term. The allegation Samsung made when it sought at the ITC to get an exclusion order against Apple's products was that Samsung had offered to license Apple the patent on FRAND terms, and Apple refused, Conversely, Apple argued, no, Samsung never offered to license us its patent on FRAND terms, and therefore it shouldn't be allowed to enforce the patent. And ultimately, in that case, the U.S. trade representative decided that there was an insufficient record to make it clear that Samsung had in fact offered its patent on FRAND terms. And so the U.S. trade representative didn't allow the International Trade Commission to block the Apple phones from being imported into the United States.
Yeah.
And that really called into question, gosh, these standard essential patents that are in all kinds of technologies around the world, most prominently cell phones, can I really enforce my standard essential patents? Do I want now to contribute my technology to the standard if I feel like then I'm never going to be able to enforce the patent? It really, I think, roiled the innovation system for a period of time. It's really an argument that continues to this day.
Yeah. So let's maybe take a step back and do a little 101 on standard essential patents. So longtime ChinaTalk listeners may remember a show we did about 2 years ago, which told the 200-year-old history of international standards. But basically, standard essential patents, as Brian alluded to, are the reason we have things like 5G. Because lots of different companies all around the world get their engineers to solve a portion of it, and then they all have these meetings and fight over what percentage of work they should be credited for and what of their technology ends up going into the standard. And once everyone agrees, okay, this is what 5G looks like, then folks get paid out a percentage of whatever they all the companies have agreed to, and we all get to have the same 5G phone go anywhere on the planet and still work. First, this is just like a cool thing that humanity has figured out how to sort of like play nice with, which I think is worth meditating on for a second. But broadly, yeah, how has the standard essential patent universe, aside from this the Samsung story, evolved over the past few decades?
Yeah, I think the big question about standard essential patents is how can they be enforced? And specifically, can standard essential patent owners get injunctions against infringers? And can they get exclusionary relief, exclusion orders at the ITC? That is really the crux of the argument. There are some who say, no, never. You should never be able to, because standard essential patent owners have an incredible amount of market power because their patent is included in a standard that these companies must use. And so they should never be able to enforce these patents. There are others, and I fall into this camp, there are others who think, well, this negotiation process that we've set up, where the standard essential patent owner must offer to license the patent on FRAND terms, and there has to be a willing licensee, so the person seeking to use the patent has to be willing to take a license to the patent, which sets up this negotiation. To be honest, Jordan, that has worked. I mean, that's the way the system has worked since it evolved. The people, from my perspective, who argue that, no, the standard essential patent system is broken. We have to make sure that these patents can't be enforced through injunctions or exclusionary relief, or because it's leading to anti-competitive impacts. My proof point to you is to point out that there are 8 billion humans on planet Earth right now, and I think there's something like 10 billion cell phones, and every one of those cell phones is going to be replaced in the next 2 years. It's hard for me to see if there was anti-competitive effects of the standard essential patent system, because, when you have a lack of competition, that restricts product, right? That makes it so that it's harder to get a particular good. That's not what we see with cell phones. I think the system has worked every day to create the profusion of technology that we see. There are a handful of circumstances where you do have intransigent companies on one side or the other, but I think the litigation system exists to help work that out.
So let's define some terms, Brian. What are the two things that people want to do if they feel like their standard essential patent is being violated?
Well, let's say you are a standard essential patent owner. and someone is using the standard and therefore using your patent, because the definition of a standard essential patent is the patent is necessarily infringed when a standard is utilized. So if I'm the patent owner and you're using the standard, I come to you and say, hey, I see you're using this standard. You know, I have a standard essential patent that's incorporated into that standard. You need to license that patent from me. And here I'm going to make an offer to you to license that patent on fair, reasonable, and non-discriminatory terms in accordance with the rules of the standard setting organization that developed the standard. And you then would say back to me, I don't think that's a fair and reasonable and non-discriminatory offer. I think that's an unreasonable offer. You're asking too much, so go pound sand. And then I will sue you, and I will try to tell the court or the International Trade Commission, if I'm seeking an exclusion order from import of the goods to the United States, I would say to them, I offered to license my standard essential patent to Jordan on FRAND terms, and he is an unwilling licensee. And you would argue to the court or to the International Trade Commission, I am a willing licensee, but Brian is refusing to license his standard essential patent to me on FRAND terms. The court or the commission will then look at the record in the case and make a determination who's right.
Let's define FRAND first. Like, what is, what are the parameters that people argue about when one side says FRAND and the other side says no FRAND?
Yeah. FRAND, fair, reasonable, and non-discriminatory, is purposefully not a defined term. If you know anything about antitrust law, the most simple thing to know is competing parties can't agree on prices, right? That's the classic antitrust violation. So it's the entities who are part of a standard setting body can't all get together and agree, okay, $100 is a FRAND term, because that would be setting a price. FRAND is a negotiated construct, and it can take different terms depending on who the counterparty is. So if I were negotiating with you, I may say, pay me money. If I were negotiating with somebody else, I may say, hey, let's cross-license our patent portfolio, and that'll be enough for me. That'll be a FRAND thing. Or if I were talking to a third person, I'd say, why don't you pay me this amount, and I'll license you some of this patent. And that, too, could be a FRAND determination. It's a very fact-specific inquiry. What is FRAND? But what's easy is if I agree to license to you for $100, the same patent, that I tell somebody else I'm not going to license it to you except for maybe $1,000. It's clear to me that that second offer is not a FRAND offer.
And does like every contract with a standard essential patent have to be public or something? Like how do you get to the bottom of this?
Well, it's a determination by the court, and it's a good question. Upon whom does the standard of proof lie? If I'm saying it's FRAND and you're saying it's not FRAND, it's an interesting point. I'm as I sit here, because I don't litigate these things, I'm not sure who has the burden of proof, who needs to come and say, my goodness, it's a FRAND offer. If it's me, perhaps I need to go tell the court, hey, here are the other licenses that I've negotiated. Here's the terms. And the terms that I'm negotiating with Jordan fall right in line with these other terms.
But there's no like central clearinghouse where like, I don't know, it's like the NBA and you can see all the salaries, right? Like you only get to that point once you are in litigation, presumably.
That's right. There is no central clearinghouse. And in fact, nor is there any central clearinghouse that decides you in fact have a standard essential patent. The way this system works is a whole bunch of engineers from the companies that are the members of the standard setting body sit around the table and they solve a problem. How are you going to make sure that cell phones work inside buildings, right? They solve the problem with a particular technology. And then the standard setting body asks its members sitting around the table, do any of you believe that you have patents that read on this standard? And then the companies at that point, by the rules of the standard setting body, typically have to raise their hand and say, yes, I have a patent that I believe is standard essential. I believe it reads on the standard. But the organization doesn't say, okay, you're right, it's an essential patent. That determination, whether a patent actually is a standard essential patent, is made during the course of litigation. So in my example I gave you earlier, when I'm telling the court, hey, I agreed to license my standard essential patent to Jordan on fair, reasonable, and non-discriminatory terms, I might also conversely say, actually, my patent is not standard essential. And so I didn't have the obligation to license on FRAND terms. So there could be any number of different arguments like that. And it's really the court that makes the determination. Conversely, by the way, because you are certainly using the standard, right? You are a cell phone company using the wireless standard. And I'm saying I have a standard essential patent I agreed to license on FRAND terms. You don't want to admit infringement. So you would say the patent is not standard essential. So I'm not infringing it by using the standard. But even if it is standard essential, he didn't agree to license it to me on FRAND terms. That's how this litigation would go.
All right. So let's say you win and I'm violating. And the courts, in their infinite wisdom, with their many, electrical engineering degrees, decide that this is the case. Like, what are your moves to punish me?
Well, look, most patent owners, especially in this circumstance, who own standard essential patents, they want to license their technology. They don't want to be in court fighting about it. And 99 times out of 100, if not 999 times out of 1,000, that's what ends up happening. The standard essential patent owner and the user of the standard, or the implementer of the standard, they agree on license terms. So if you were to lose and the court said, Jordan, hey, you are infringing this patent, or the ITC said, yep, we're going to issue an exclusion order, then the standard essential patent owner basically would say, okay, I'm obligated to license to you on FRAND terms. Let's discuss what that is now. Or I guess you could say, well, I'm going to stop implementing the standard now. But chances are you're going to want a license.
So what's an exclusionary order?
The International Trade Commission is a body that was established in 1930 to protect from U.S. commerce imports that infringe U.S. intellectual property. A little more complicated than that, but that's the simple terms. So if you are a U.S. company and you believe an import infringes your intellectual property, you can file a petition at the U.S. International Trade Commission asking that the commission issue an exclusion order. What that does is it tells the Customs Department, don't let this product into the United States. Again, that's a little simplistic, but that's the easy way to explain it.
Gotcha. So, Brian, let's take it to the EU. What's the patent drama going on over there?
Right. So the European Commission proposed and the European Parliament passed relatively recently a series of changes to their intellectual property system that also included some changes to how the SEP system would work in Europe. And as I recall, part of the changes included creating a government bureaucracy to determine essentiality of patents, whether a patent is a standard essential patent, and provide some sort of recommendation for what the license value should be for those patents. And I think there's a couple areas of concern for this. The first is it really does seem to undermine the value of standard essential patents. You do have in Europe some very large and successful companies that own quite a large portfolio of standard essential patents, most notably Nokia and Ericsson. There's the scuttlebutt on this is that the EU was motivated to adopt this regime that I would say dumbs down standard essential patent and kind of handcuffs standard essential patent owners a little bit, because automobiles are becoming effectively cell phones on wheels. And the auto companies, and most specifically the German auto companies, want to get access to that technology as cheaply as possible. And so the idea is, well, let's make it difficult for the owners of standard essential patents to really negotiate much in the way of licensing fees from the auto companies. So that's the scuttlebutt. on those regulations. I should note, too, these licenses that we're talking about for standard essential patents are pretty modest in the grand scheme of things. I don't know about, Jordan, if you've ever driven a Tesla, just to pick on Tesla. The LiDAR technology that and all the Wi-Fi technology that kind of allows you to see where the cars are kind of around you as you're driving in a Tesla. For that technology, I pay, I think, $99 a year, every year. That's a license that I buy from Tesla in order to have that capability in my car. I believe Tesla pays something on the order of $20, maybe $25 for a lifetime license to that technology per car. So for an investment of $25, Tesla is making $99 a year for me for the life of my car. Seems like a pretty good deal for Tesla. I'll give you another example. When Apple and Qualcomm were having their global thermonuclear war about Qualcomm standard essential patents, I think there was public reporting that the amount of money Qualcomm was charging for a license to Apple phones was something on the order of $10. $10 per iPhone. I don't know if you're old enough, Jordan, to remember the iPod Touch. This was a technology that looked like an iPhone. The only thing it lacked was the wireless technology that's really Qualcomm technology. An iPod Touch sold for, I think, something like $300 or $400. An iPhone, of course, is closer to $1,000. So for that differential in price, that $500-$600 difference, say, Apple was obligated to pay a $10 license fee to Qualcomm. So it's not the case that these standard essential patent owners are some rapacious characters trying to squeeze the lifeblood out of these technology companies. I think quite the opposite. I think many of these technology companies think of it as a volume game. If all of these 10 billion cell phones on planet Earth have to be replaced in 2 years, and I can shave even just a few cents off the cost I have to pay to license the technology for each of those cell phones, that's a lot of money to my bottom line. So that's what happened in the EU. And the concern about that, too, is that it also seems to give aid and comfort to China. And this is really an important point I want to make, not just about standard essential patents, but patents more generally. So in China, there has been an effort on the part of Chinese courts to accrue to themselves the authority to set global licensing rates for standard essential patents. So effectively, you've got a court in China telling a US company or a European company what they can charge not only for Chinese users of the technology, but any user of the technology all over the world. That really undermines the value of standard essential patents. And of course, it's in the interest of Chinese courts to do so because many of them are necessarily using US technology. And so by Chinese courts setting artificially low global licensing rates for primarily American and European companies, that has a double whammy for the Chinese of giving their cell phone manufacturers like Huawei or Oppo or some of these others cheaper access to the technology they need. It also serves the benefit of undermining great American and European technological champions, which is beneficial to the Chinese in their geostrategic competition with the United States.
Sure. So let's stay on that for a second at the ground level. So like, say a Chinese phone manufacturer wants to use a Western patent, and then, they say it's FRAND, the other people say it doesn't FRAND, and there's a big fight. Like where is the jurisdiction? How does that end up playing out?
Well, what we've seen, certainly in the case of these Chinese handset makers, is that they will file suit, declaratory judgment action, saying the patent is invalid in China, precisely to get access to the Chinese courts, so that the Chinese courts are the ones who can make this global licensing determination. But I want to just talk generally about China. I said at the outset that I'm really an international trade lawyer who happens to have this patent background. So I view the U.S. patent system in the context of our competition with China. China famously, a few years ago, issued a document called Made in China 2025, which articulated China's plans to dominate the technologies of the future in biotechnology and wireless communications and aerospace, quantum computing, others. And the benefit, or I should say the advantage China has in some respects, is that if the Chinese government, being a command and control economy, if they want to invest $50 billion, $100 billion in a technology, they snap their fingers and that investment is made. In the United States, we have a market-based system. And so we rely on the incentives that policy provides to channel private sector money into the innovation ecosystem. And the patent system is one of the foundations of that policy architecture that provides the incentive for private sector companies to invest heavily in invention in the United States. I submit to you that the way the patent system has evolved over the last 10, 15 years has left us in a circumstance where that kind of early stage innovation, the kind of innovation that you really want to see, has seen a real drop-off in investment. You have, for instance, in a circumstance where there are all kinds of patents that people in the United States can't get or that are ruled invalid, unpatentable, inventions that are unpatentable here, that are patentable in Germany, in China, elsewhere. And of course, if you come up with an invention and you want to develop an industry, you're going to go where you can protect that technology. So all the investment for these new inventions is not in the United States, it's elsewhere. So I really hope that policymakers do think about the patent system in the context of our competition with China and really do try to bring our system back to a circumstance where patent rights are predictable and stable so that private sector investment can really flow into those areas that are going to make our economy and our country strong really for the long term.
Let's stay on the how the fight plays out, and maybe this is how we bring it to the international level. So a Western firm gets a ruling they're not particularly happy with. In the Chinese court, they're offering $1, you want 10 or whatever. Is there? I mean, I guess there's not the WTO. How is this solved in the China context? And then, how is something like the USMCA or TPP or other sort of international trade agreements of recent vintage trying to, take these questions on?
Well, trade agreements don't really get at the standard essential patent pieces.
Sure.
You have this funny circumstance where you have a court in China telling or essentially assigning to itself the right to set these global licensing rates. But then you'd have the standard essential patent owner going to a different court, maybe in India or somewhere else, getting an anti-suit injunction against that lawsuit in China, saying, Chinese court, you can't issue this global licensing rate, and kind of having a separate competing order. So you have this crazy circumstance where you have battling court decisions. Now, ultimately, I think what ends up happening is these companies will settle with one another, but not after a whole ton of litigation. So it's pretty messy, but it's that concern that I think many standard essential patent owners have with the EU seeming to give aid and comfort to the Chinese in their efforts to become the kind of the forum in which global licensing rates are set for standard essential patents by undermining the standard essential patent architecture in Europe.
I'm curious, give me the anthropology, if you wouldn't mind, of international trade lawyers who focus on technology and patents. Who ends up getting into this field and what are they like?
Sure. I should first give you maybe my bona fides on patents and IP policy, since you're right, my position in the Congress was as the Chief International Trade Counsel of the Senate Finance Committee. But actually, my experience with intellectual property goes back further. I actually have a degree in mechanical engineering, of all things, a very strange thing for a lobbyist like me to have. And then I am a member of the U.S. Patent Bar, which I took as I was trying to avoid work in my private sector law firm at the time, thinking that studying for the patent bar would allow me to avoid work for that week. But instead, of course, I'd study for the bar from 9 to 6 and then work from 6 until 3 in the morning for a week. So that was a failed strategy on my part. But it has left me as in the unique role of being a trade lobbyist who is a member of the U.S. Patent Bar and with a background in engineering. So that's why I come at this the way that I do, not only from the standpoint of patent policy and not just from the standpoint of international competition with the United States and other countries, but how the U.S. patent system plays into the role of that international competition, and especially with respect to our geostrategic competition with China. Gosh, who ends up getting to that field? You really do. I think most people come at it from the standpoint of being IP lawyers, and they are confronted in an international context. I'm unusual in that I kind of did this in the other way, or maybe perhaps even in parallel, but I'm really a trade lawyer that happens to have this intellectual property background that's been valuable. There's actually quite a bit of an intersection between international trade and intellectual property as we've been discussing here. There are international agreements. Of course, intellectual property companies who have very valuable intellectual property are international, and so they need to defend that intellectual property overseas. So there's a lot of work there, but they tend to be pretty technical, pretty dorky, but my kind of people.
And one more question for you, Brian. You mentioned like thermonuclear war, which is something that we've seen a number of times over the past few decades, where you have these companies that are fighting over billions, if not tens of billions of dollars, but they're also sort of still doing deals with each other at the same time. And, I guess from the lawyer's perspective on things, you're just the kids and the parents are fighting, but they're still going to end up back together in some way, shape, or form. There's so much money to be made by finding terms at the end of the day that everyone still ends up finding terms at the end of the day. It's not you win the case and you put the perpetrator in jail or whatever. Any thoughts on that? It's just an interesting world to be in, kind of.
It is. Really what we're talking about is licensing fees. All of this litigation, it's really all about what are you going to charge me for a license?
Sure.
And the attempt to get leverage over what that ultimate licensing fee is. I don't think when Apple and Qualcomm were arguing over Qualcomm standard essential patents that Apple had any question that it was using Qualcomm's patents. Maybe it will argue some of them are invalid, those sorts of things. But at the end of the day, it was really an attempt on the part of Apple to be charged a lower licensing fee. That's really all it was about. And to your point, and the point I made earlier, when you are talking about billions and billions of products, just a small change in the licensing fee really can make quite a bit of difference.
Yeah.
And you do have a circumstance now, and I've been predicting this for a while, and we're now seeing it. As I've mentioned, automobiles are becoming cell phones on wheels. They now are using standard essential patents. And because that's a cost, they now are joining the side of this fight where they want cheaper access to their patented technologies. I think that's a short-sighted view for the United States generally, and maybe even for the auto companies themselves. But I guess it gets back, Jordan, to that old, where you stand is where you sit. So people are motivated by protecting their bottom lines one way or the other, and it's up to policymakers to make sure that they keep the system moving in a direction that best suits the future of the United States. That's all I ask. Think about what's best for the system, not for any one particular company.
Brian Pomper, thanks so much for being a part of ChinaTalk.
Thanks, Jordan. Really enjoyed it.